The March 2026 Visa Bulletin just dropped, and if you've been waiting for movement in the F2A category or if you're watching your employment-based priority date inch forward month after month, what I'm about to tell you is going to feel like a punch to the gut. Because after months of hope that we'd see meaningful progress in the second quarter of fiscal year 2026, the numbers tell a very different story. And if you don't understand what's happening right now with final action dates, filing dates, and why certain categories are frozen while others are moving, you could miss your window entirely or waste months preparing documents for a date that isn't actually current yet. This affects hundreds of thousands of people, and the decisions being made right now at the State Department are going to determine whether you wait another 6 months, another year, or whether you finally get the chance to move forward. So if you have a priority date, if you're waiting on a green card, or if someone you love is stuck in this backlog, do not leave this video because I'm going to break down exactly what just happened, why it happened, and what you need to do in the next 30 days to protect your case. Welcome to Legal Focus USA, where we cut through the confusion and bring you clear, accurate, fact-based immigration analysis. I'm here to walk you through the March 2026 Visa Bulletin, line by line, category by category, so you know exactly where you stand and what comes next. Before we go any further, here's the legal disclaimer. I am not an attorney. This content is for educational and informational purposes only. Immigration law is complex and highly individualized. Always consult with a licensed immigration attorney for advice specific to your situation. What I'm sharing today is based on official data released by the U.S. Department of State and publicly available USCIS guidance. Now, let's talk about what the March 2026 Visa Bulletin actually says, and more importantly, what it means for your case. The Visa Bulletin is published every month by the U.S. Department of State, and it controls the entire flow of family-based and employment-based green cards. It tells you whether your priority date is current, meaning whether you can actually file your adjustment of status application or receive your immigrant visa. Your priority date is the date that USCIS or the National Visa Center received your petition. It's your place in line. And every month, the State Department looks at how many visas are available, how many people are waiting, and they decide how far forward to move the dates. Sometimes they move forward, sometimes they stay frozen, and sometimes they actually move backward, which is called retrogression. For March 2026, here's what we're seeing. Let's start with the F2A category, which is the family preference category for spouses and unmarried children, under 21 of lawful permanent residents. This is one of the most watched categories because it affects so many families who are separated, waiting for the chance to reunite. The final action date for F2A in March 2026 has moved forward by approximately 2 weeks compared to February. That sounds like progress, but let me put this in perspective. 2 weeks of movement after a full month of waiting means that if your priority date is from mid-2023 or earlier, you're still looking at a wait time that could stretch well into 2027 or beyond, depending on how the rest of this fiscal year plays out. Here's why this is so frustrating for people in the F2A category. For years, F2A was current, meaning there was no wait time at all. If you were the spouse or child of a green card holder and your petition was approved, you could immediately move forward with your visa processing or adjustment of status. But starting in 2023, demand began to outpace supply, and we started seeing backlogs form. And now, in early 2026, that backlog is real, it's growing, and the movement we're seeing each month is not keeping pace with the number of new petitions being filed. The State Department is allocating visas based on a statutory cap set by Congress under the Immigration and Nationality Act. F2A gets approximately 87,900 visas per year, but that number is reduced by any unused family fourth preference visas from the prior year, and it's subject to per-country limits, which means applicants from countries with high demand like Mexico, the Philippines, India, and China face even longer waits. So if you're in F2A and your priority date is still not current, here's what you need to understand. The State Department is being extremely conservative with the forward movement right now because they don't want to overallocate visas and then have to retrogress later in the fiscal year. This is a pattern we see every year in the second and third quarters. They move slowly and cautiously, And then in September, right before the fiscal year ends, they sometimes make a big jump forward to use up any remaining visa numbers. But that's not guaranteed and you cannot count on it. Now, let's talk about employment-based categories, because this is where things get even more complicated. For EB2 and EB3, which are the employment-based second and third preference categories, the March 2026 Visa Bulletin shows starkly different movement depending on your country of birth. If you were born in India and you're in the EB2 category, your final action date has not moved at all. It is frozen. We're talking about priority dates from 2012, which means if you filed your labor certification and I-140 petition in 2012, you are still waiting in 2026. That is a 14-year wait, and there is no end in sight. The reason is simple: per country caps. Under current law, no single country can receive more than 7% of the total employment-based visa numbers in any given year. India has an enormous backlog of highly skilled workers, and the cap creates a bottleneck that is mathematically impossible to clear without legislative reform. For China-born applicants in EB2, the situation is slightly better but still bleak. The final action date moved forward by about 3 weeks in March 2026, but we're still looking at priority dates from 2019. That's a 7-year wait. For the rest of the world, meaning applicants born in countries other than India, China, Mexico, and the Philippines, EB2 is current. There is no wait. If your I-140 is approved and you were born in a country without a backlog, you can file your I-485 adjustment of status application immediately. EB3, the employment-based third preference category for skilled workers and professionals, shows a similar pattern. India-born applicants are stuck with priority dates from 2012. China-born applicants are seeing dates from 2019. Rest of world is current. This disparity is one of the most controversial aspects of the current immigration system, and it has been the subject of numerous legislative proposals, including efforts to eliminate per-country caps or create separate visa pools for different countries. But as of March 2026, no such reform has passed and the system remains as it is. This is where things become critical. You need to understand the difference between Chart A and Chart B in the Visa Bulletin, because using the wrong chart can cost you months of processing time or cause your application to be rejected. Chart A is called the Final Action Dates chart. This tells you when you can actually receive your green card or immigrant visa. If your priority date is earlier than the date listed in Chart A and all other requirements are met, your case can be approved. Chart B is called the Dates for Filing chart. This tells you when you can submit your I-485 adjustment of status application, even if your priority date is not yet current for final action. Filing under Chart B allows you to get into the system, receive a work permit and travel document while you wait, and position yourself for approval as soon as your priority date becomes current under Chart A. Here's the catch. USCIS decides every month whether applicants can use Chart B for filing. For March 2026, USCIS has announced that Chart B is available for most family-based categories, but not for most employment-based categories. This means that if you're in EB2 or EB3 and your priority date is current under Chart B but not under Chart A, you cannot file your I-485 yet. You have to wait until your date is current under Chart A. This is a source of enormous frustration because Chart B dates are often several months or even years ahead of Chart A dates, and the ability to file early can make a huge difference in terms of work authorization and travel flexibility. But here's what many people are misunderstanding. Even if you can file under Chart B, that does not mean your green card is coming anytime soon. It just means you can submit your paperwork and start the process. Your case will not be approved until your priority date is current under Chart A. So, if you see Chart B and you get excited because your date is current, don't assume you're getting a green card in the next few months. You're getting the ability to file, which is valuable, but it's not the same as approval. Let me give you a real example to make this concrete. Imagine you're Maria, born in Mexico, and your husband is a lawful permanent resident. He filed an I-130 petition for you in July 2023, so your priority date is July 15th, 2023. You've been waiting in Mexico, separated from your husband and your kids, hoping that your priority date will become current so you can go to your consular interview, and finally reunite with your family. You check the March 2026 Visa Bulletin, and you see that the final action date for F2A is July 1st, 2023. Your priority date is July 15th. You're not current yet. You're 2 weeks away. So you wait another month, you check the April Bulletin, hoping to see movement, and maybe the date moves to July 22nd. Now you're current. The National Visa Center contacts you, tells you to submit your documents, and you schedule your interview. But here's the reality. You've been waiting nearly 3 years for this moment, and even now, there's no guarantee. If there's any issue with your documents, any inconsistency in your application, any red flag in your background check, your case could be delayed further or even denied. The emotional toll of this process is crushing, and the uncertainty is constant. Or imagine you're Raj, born in India, working in the United States on an H-1B visa as a software engineer. Your employer filed your labor certification in 2012, and your I-140 petition was approved in 2013. Your priority date is September 2012. You've been waiting for over 13 years. You check the March 2026 Visa Bulletin, and the EB2 India final action date is still stuck at August 2012. You're 1 month away. 1 month after 13 years. And you have no idea when that date is going to move forward. It could move next month. It could stay frozen for another 6 months. You're locked into your job because changing employers could jeopardize your status. Your kids are aging out, meaning they're about to turn 21 and lose their eligibility to immigrate with you. Your entire life is on hold because of a priority date that moves at a glacial pace, if it moves at all. These are not hypothetical situations. These are real people, real families, real lives that are shaped and constrained by the Visa Bulletin every single month. And the psychological weight of watching those dates, hoping for movement, and seeing minimal progress is something that policymakers in Washington often fail to fully appreciate. So why is movement so slow right now in March 2026? Let me explain the mechanics. The U.S. immigration system operates on a fiscal year that runs from October 1st to September 30th. We are currently in the second quarter of fiscal year 2026, which runs from January through March. Historically, the State Department is very conservative with visa allocations in the second and third quarters because they want to avoid a situation where they run out of visas before the end of the fiscal year. If they move the dates forward too quickly and then realize they've over-allocated, they have to retrogress, which means moving the dates backward. Retrogression is devastating for applicants because people who thought they were about to become current suddenly find themselves months or even years away from approval again. So the State Department plays it safe. They move dates forward slowly and incrementally in the middle of the fiscal year, and then in the final months, typically August and September, they assess how many visas are left, and they make a final push to use up the remaining numbers. This is why you sometimes see big jumps in priority dates in September. But again, that's not guaranteed, and it depends entirely on how many visas have been used up to that point and how much demand remains in the queue. Another factor affecting movement right now is the end of pandemic-era processing delays. During COVID, consular posts around the world were operating at reduced capacity or were closed entirely. This created a massive backlog of cases that were approved but couldn't be processed because interviews weren't happening. Now that consular operations have largely returned to normal, we're seeing a surge in visa issuances, which means the State Department is burning through available visa numbers faster than they did in prior years. This is actually contributing to slower forward movement in priority dates because the visas are being used up more quickly. There's also the issue of administrative processing. Even if your priority date is current and you go to your consular interview, you could still be placed in administrative processing, which is an additional security and background check that can take weeks, months, or in some cases over a year. Administrative processing is particularly common for applicants from certain countries or for cases involving complex employment histories or prior immigration violations. And while you're in administrative processing, you're in limbo. You can't get your visa, you can't make plans, and you have very limited recourse to speed up the process. This part could affect you even if you think it doesn't. Even if you're not an F2A, EB2, or EB3, the movement in those categories affects the overall system. If the State Department allocates more visas to one category, it can impact the availability of visas in other categories due to cross-chargeability rules and statutory caps. The entire system is interconnected, and a freeze or retrogression in one area can have ripple effects across the board. Here's what you need to do right now. First, check your priority date immediately. Go to your I-797 Notice of Action, which is the approval notice for your I-130 or I-140 petition. Your priority date is clearly listed on that document. Write it down, memorize it. This is the single most important date in your immigration case. Second, compare your priority date to the dates listed in the March 2026 Visa Bulletin. You can find the Visa Bulletin on the State Department's website. Look at Chart A for final action dates and Chart B for filing dates, if applicable. Determine whether you are current, close to current, or still far from current. Third, if your priority date is within 6 months of the current date, start preparing your documents now. This includes gathering financial documents, police certificates, civil documents like birth and marriage certificates, and most importantly, completing your medical examination on Form I-693. The medical exam is only valid for 2 years from the date the civil surgeon signs it, so timing is critical. You don't want to complete your medical too early and have it expire before your interview, but you also don't want to wait until the last minute and cause delays. Fourth, if your priority date is current or about to become current, consult with a qualified immigration attorney immediately. Do not try to navigate this process alone. An attorney can review your case, identify potential issues, and help you prepare a strong application. They can also advise you on whether you should file for adjustment of status in the United States or pursue consular processing abroad, which is a strategic decision that depends on your individual circumstances. Fifth, avoid scams. Right now, there are people and companies out there claiming they can speed up your priority date or guarantee you a green card for a fee. This is fraud. No one can move your priority date forward except the State Department through the Visa Bulletin. No one can guarantee approval of your case. If someone is making these promises, they are lying to you and they are likely violating federal law. Only work with licensed attorneys or accredited representatives recognized by the Board of Immigration Appeals. Sixth, monitor official USCIS and State Department announcements. Immigration policy can change quickly, and you need to stay informed. Sign up for email updates from USCIS, check the Visa Bulletin every month, and follow credible immigration news sources. Do not rely on rumors or social media speculation. Now let me give you the broader context of what happens next. The March 2026 Visa Bulletin is just 1 month in an ongoing process. In April, the State Department will release the next bulletin, and we'll see whether dates move forward, stay frozen, or retrogress. Based on historical trends and current allocation patterns, my expectation is that we will continue to see slow, incremental movement through the spring and summer, with the possibility of larger jumps in August and September as the fiscal year comes to a close. However, this prediction is based on normal patterns, and immigration policy is anything but predictable right now. There is also the possibility of legislative reform. There have been multiple bills introduced in Congress over the past several years aimed at addressing the green card backlog, including proposals to eliminate per-country caps, recapture unused visa numbers from prior years, and increase the overall number of employment-based visas. But as of March 2026, none of these bills have passed both chambers of Congress and been signed into law by the President. Legislative reform requires a majority vote in both the House and the Senate. And in the current political environment, immigration reform is highly polarized and difficult to advance. Even if a bill were to pass the House, it would need 60 votes in the Senate to overcome a filibuster, unless it's included in a budget reconciliation package, which has its own limitations. And even if Congress were to pass reform, it would take months or even years for the new system to be implemented through regulatory rulemaking by USCIS and the State Department. So, while we can hope for legislative solutions, we cannot count on them. You have to plan based on the system as it exists today, not the system as you wish it would be. That means understanding your priority date, preparing your documents, and being ready to act when your date becomes current. However, this protection is not permanent. Even if your priority date becomes current and you file your adjustment of status application, your case can still be denied if you have any issues with admissibility, including criminal history, immigration violations, fraud, or health-related grounds of inadmissibility. Filing your I-485 does not guarantee approval. It simply means you're in the queue and you're being processed. You still have to meet all the legal requirements for a green card, and USCIS has broad discretion to deny cases that don't meet those standards. Let me also address a question that comes up constantly. What if my priority date becomes current but I'm not ready to file? This happens more often than you might think. Maybe your civil documents expired. Maybe your medical exam is outdated. Maybe you changed jobs and you need to port your I-140 to a new employer under the AC-21 provisions. If your priority date becomes current and you're not ready, you could miss your window. Priority dates can retrogress, meaning they move backward, and if that happens, you'll have to wait until your date becomes current again. This is why preparation is so critical. You need to have everything ready to go so that the moment your date is current, you can file immediately. For people in employment-based categories, there's an additional complication related to job mobility. If you have an approved I-140 and your priority date is not yet current, you're generally tied to your sponsoring employer. If you leave that job, you could lose your priority date unless you invoke the portability provisions under INA Section 204J, which allows you to change jobs to a similar position after your I-485 has been pending for at least 180 days. But if your priority date is not current and you haven't filed your I-485 yet, you don't have portability protection. This creates a situation where workers are essentially locked into their jobs for years, unable to take better opportunities, unable to negotiate for higher salaries, and unable to start their own businesses. The economic and personal costs of this are staggering, and they affect not just the individual workers, but their families and the broader economy. Let me talk about what this means for families, because the human impact of the Visa Bulletin goes far beyond paperwork and processing times. When you're waiting for a priority date to become current, you're often separated from your spouse, your children, or your parents. You're missing birthdays, anniversaries, graduations, and funerals. You're living with the constant stress of uncertainty, not knowing when or if you'll be able to reunite. You're making impossible decisions about where to live, where to work, and how to maintain relationships across thousands of miles in multiple time zones. And the financial cost is enormous. You're paying for immigration attorney fees, filing fees, medical exams, document translations, and travel expenses. You're potentially losing income if you can't work while you wait, or if you have to turn down job opportunities because of your immigration status. The total cost of obtaining a green card from start to finish can easily exceed $10,000 or $20,000, and that doesn't include the opportunity costs of years of delayed career advancement or family separation. This is not just an administrative process. This is people's lives. And the Visa Bulletin, as dry and technical as it may seem, is the mechanism that controls whether those lives move forward or stay frozen in place. So when I tell you that the March 2026 Visa Bulletin shows minimal movement and that we're likely to see slow progress for the rest of the spring, I'm not just talking about numbers on a chart. I'm talking about hundreds of thousands of people who are waiting, hoping, and doing everything they can to navigate a system that is complex, opaque, and often deeply frustrating. If you want accurate, fast, and reliable immigration updates, subscribe to Legal Focus USA right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential. Drop a comment below and let me know what visa category you're in, what your priority date is, and how long you've been waiting. I read every comment, and your feedback helps me create the content that matters most to this community. If this video helped you understand the Visa Bulletin better, hit the like button and share it with anyone else who's waiting for their green card. They need this information just as much as you do. Thank you for watching, and I'll see you in the next update.